Well, the 2016 Family Law Specialist Conference is in the books, and I told you guys I would report back on anything interesting I found out. There's a lot of inside baseball stuff this year, mostly things that attorneys will find interesting for doing what we do behind the scenes, but maybe not as interesting for clients. There was one point, though, about marital debts that I thought I should pass on. Now, the rules for assets and debts are different in North Carolina. An asset is presumed to be marital if it was acquired during the marriage, unless one side or the other proves that it meets the definition of separate property. With debts, it's the opposite. The debt is presumed to be the separate obligation of whoever's name it's in, unless you can show that it was incurred for the joint benefit of the parties. It's called the joint benefit rule, and it gets litigated a lot. Well, a case came out last year that I didn't know about, where a home equity line of credit on a house was assigned to just one party as their separate debt because the other spouse persuaded the trial judge that she didn't know that it had been taken out and wasn't consulted about any of the withdrawals made from it. Well, I thought about that, and I could understand that person's gripe, but objectively, you don't have to know about a debt to have benefited from it. What if all the withdrawals on that home equity line had been for medical bills for the parties, or for their children, or for groceries during a period when one side was unemployed? I'll bet, and I think this was the case, that the husband was probably doing some things that the court didn't feel were really for the joint benefit with the money from that home equity line. But that's not exactly what the court said. So now you've got this case out there that people can use to argue that ignorance of a debt is enough to not have to share in it, even if it might have technically benefited both parties during the marriage. I think this is a stay tuned issue, something that the Court of Appeals is going to have to clarify, and so I will stay on it, and when we get some clarification, I can update this post and I'll give it to you guys as soon as it's available.